Legacy Precious Metals is the company that I trust to give you good and patient counsel for investing in your retirement. The Biden administration has caused a financial crisis, and they have no clue how to fix it. Oil prices have skyrocketed, and when oil prices go up, not only do your expenses go up, but the cost of transportation and shipping spikes, leading the prices of goods to rise. And we are already seeing record inflation. That's the last thing that we need. Our economy is in trouble, and you need to take steps to protect yourself. If all your money is tied up in stocks, bonds, and traditional markets, you may be vulnerable. So gold is one of the very best ways to protect your retirement. No matter what happens, you own your own gold. It's real, it's physical, and it's always been valuable since the dawn of time. Call Legacy Precious Metals today at 866-528-1903 or visit them online at legacypminvestments.com. That's legacypminvestments.com, where you can download the free investor's guide. You can also go to my Facebook page, Jenna Ellis. I am a public figure on Facebook, and I just posted yesterday a really great interview with the president of Legacy Precious Metals, who is discussing why you need to start your retirement account even if you're in your 20s or 30s. There is always a great time to protect your retirement and invest, just like you want to protect your health over the long term. So go to Legacy Precious Metals at legacypminvestments.com or call 866-528-1903.
As a constitutional law attorney, former senior legal advisor, and personal counsel to President Donald J. Trump, Jenna Ellis believes in the rule of law and the importance of integrity in our elections. And she's ready to tackle the big cultural and legal issues facing America. This is the Jenna Ellis Show. Here is your host, Jenna Ellis.
Happy Monday, friends, and welcome to another episode of the Jenna Ellis Show. I'm Jenna Ellis, and the headline just dropped today on a Monday that Elon Musk is actually acquiring Twitter. So today has been a day all about free speech, and I am so excited to see where the platform heads and how Elon Musk is going to actually protect the principles of the First Amendment and free speech, even within the context of Twitter being a private platform. And so I think a lot of conservatives are celebrating that. We also want to talk about today, though, and emphasize the Supreme Court arguments that you may not be aware of happening today, earlier at the Supreme Court. So Coach Kennedy, who was a coach at Bremerton High School, he was a football coach, and just as a very sincere Christian, after each game would go by himself, not even, having students involved, anything, just a private moment, and kneel at the 50-yard line and have a prayer to the Lord for just a few seconds, probably under 30 seconds. And the high school district decided that was an interference of religion, and that was an expression that they didn't want to get sued over, so they decided to fire him. And so this case has been ongoing for quite a while. I first met Coach Kennedy years ago when I was working for Dr. James Dobson out in Colorado, and with the senior counsel of First Liberty that represents him, Kelly Shackelford. And that was a number of years ago. This case has been pending for a while. The Supreme Court finally today heard oral arguments and is going to determine this question of when is private speech appropriate, even if you are a high school football coach, or you are a Christian or someone of religion that happens to also be employed by a public school or by the state. So this is an incredibly important case, not only to free speech and religious liberty, but all of the First Amendment principles. It also has a really significant opportunity to clarify provisions of case law from the Supreme Court that have been a little bit muddy and not really that effective over the course of the last 30 and 40 years. So I listened to the whole oral argument today, and what was fascinating to me is that the justices were asking a lot of philosophical questions and hypotheticals. So that happens all the time in terms of the Supreme Court, but a lot of these questions were geared toward, well, okay, what if this? What if we change the facts slightly? Would that still be First Amendment protected speech, or does that then get into the state entanglements in the Establishment Clause and saying that, this isn't okay in terms of free speech, and the state would have the right to curtail that speech. And so a lot of these hypotheticals were interesting. It was also, to me, interesting to hear how a lot of these very contentious back and forth between the justices, I ended up tweeting, I think they could benefit sometimes from conflict resolution counseling, because a lot of these things are just conflicts that then, as the court is analyzing this, they end up getting sometimes into a contentious sort of discussion with the lawyers representing both sides. And that is particularly true for Justice Sotomayor. I honestly get so frustrated listening to her because she tends to just over-bloviate during the arguments and wasting a lot of time for the advocate that you know is representing the side that she opposes. And so she's wasting a lot of their time, and she's on purpose just trying to badger them. So I thought that the advocate representing Coach Kennedy in association with First Liberty did a really excellent job at being both respectful, but also pushing back and getting his arguments on the record. So I'm going to have a senior counsel from First Liberty on to further break this down. But the bottom line here is that we need to be praying that the Supreme Court, with the hopefully conservative majority, which you all know my feelings about that, hopefully they will not only hold in favor of Coach Kennedy, who literally absolutely has the right for this type of speech to be protected under the U.S. Constitution. He should win this case. But we also need to pray that it isn't a narrow opinion that is kind of tailored in a way to address his situation without a more full expression and opinion on First Amendment jurisprudence. There's a huge opportunity here for the court to reaffirm and clarify some standards of law under the Constitution that can give guidance to lower courts, can give guidance to state entities who really do need to abide by constitutional protections. And, this is the time that we're talking about free speech in so many different ways. We're talking about that not only in the Supreme Court today, we're talking about that in the context of public forums like Twitter. We talk about it in the context of Section 230. I've been talking about it in the context of the Walt Disney Company in Florida and the freedom to oppose legislation, even when it's not a viewpoint that a lot of people prefer. So these types of conversations are very important to not only preserving and protecting the constitutionally protected rights for all, but making sure that we understand how to parse these issues. So we'll be right back after this with Stephanie Taub, who is a senior counsel for First Liberty. I also want to talk about another great American who is the sponsor of this podcast, and that, of course, is my good friend Mike Lindell. He has been canceled out of so many box stores for simply standing up for his own political opinion. And disagree or not, or support him or not, it is a fundamental right of every American to be able to voice their opinion, and that absolutely includes politics. That absolutely includes issues that are central to our culture. That includes faith. Mike is such a very sincere Christian, and I am proud to consider him a friend, and he is, of course, a friend of this show. So right now, there is a special on MyPillow.com. Click on the new radio listener specials. Get deep discounts on all MyPillow products, including a great towel set, which is a 6-piece set. It includes 2 bath, 2 hand towels, 2 washcloths, made in the USA, regularly $109.99, now just $39.99, but you have to use the promo code Jenna. That's JENNA. That tells Mike that you listen to this show, you're happy that he is a sponsor of this show, and you will get great discounts, but use the promo code Jenna, that's JENNA, either at mypillow.com or call 1-800-564-8475 and use the promo code Jenna. So joining me now to discuss is Stephanie Taub, who is senior counsel with First Liberty, who of course is representing Coach Kennedy in this case. Stephanie, thanks so much for joining me today.
Thank you for having me on to talk about this important case.
It is really important. And, even though there's all the headlines about Elon Musk buying Twitter, and that's a great thing for free speech, First Liberty was actually arguing free speech at the United States Supreme Court this morning. And so I listened to the full oral argument and found some of the questions from the justices really interesting in terms of their hypotheticals and exactly when school begins and when it ends, and when a coach or anyone employed by the school is exercising personal speech versus speech on behalf of the school. So break this down for me. What was your impression of the argument?
So overall, we thought the argument went very well. You're right that this argument did get at a lot of philosophical questions, really, about the First Amendment and what's the interplay between the different clauses here, the free speech clause, the free exercise clause, and the establishment clause. So one really interesting point is, well, I guess just stepping back for a moment to tell your listeners what the case was about. So we represent Coach Kennedy. He is a Marine veteran turned high school football coach who lost his job after taking a knee at the 50-yard line after games to engage in a 15 to 30-second prayer. So the school district fired him because he could be seen doing something religious, and specifically because they feared being sued under the establishment clause under an endorsement theory. So this is a case that will clarify whether that Supreme Court promise that teachers as well as students don't lose their First Amendment rights when they cross onto the schoolhouse gates. Do teachers actually have First Amendment rights? Do they still, and will those rights be protected?
Right. So what was your overall impression of the argument?
I thought the argument went very well. We're very honored to be to have Kirkland and Ellis on our team, and Paul Clement from our side, who's former U.S. Solicitor General, presented the argument. He's argued more cases than just about anyone, over 100 cases before the United States Supreme Court. So the argument did go very well. The justices were focused on in a few questions on, as you mentioned, whether this is government speech or whether this is private speech. So when a coach engages in this brief prayer, or for instance, if a coach were to cross himself before games right after games, is that a speech attributable to the school that the school can censor, or is this the private personal expression of the individual at issue?
Yeah, and one of the questions that I thought was fascinating from, I believe it was Justice Breyer, was saying, okay, well, how far in time can a school district go to say, okay, just from maybe right before the bell, 9 to 9:15, say that just in that time we don't want to have any sort of religious speech right before, as students are walking into class or walking out, for example, and would that be protected? So some of those hypotheticals I think are really interesting to listeners, because the understanding of what actually constitutes speech when you are employed by a school district, I think really gets at the crux of the issue here. So I, like you, thought Paul Clement did a fascinating, wonderful job with this case. But so specifically, to that type of question, what's the response to a question saying, okay, well, a school district or a public employer can foreclose speech for just a very narrow time period?
Yeah, so I think Paul Clement's response and our response generally is schools are free to create rules to limit speech in certain ways, as long as they're neutral. So as long as they're being applied equally. So what you can't do is you can't say, oh, you can take 30 seconds to engage in some sort of private speech, but not if that speech is religious. That's religious discrimination, and that should put you in a framework of looking at this under the normal way we look at religious discrimination against students that are being discriminated against on that basis. And so why should teacher speech be treated differently?
Yeah, and I think that's an important distinction, that if it is a neutral law that is generally applicable, then that usually is the test to see whether or not it's specifically targeting a particular religious expression. And so for Coach Kennedy, he was specifically targeted and singled out by the school district for this particular speech that if anyone else, including a student, had taken a knee privately and very quickly before or after a game, they wouldn't have experienced any sort of penalty by the school district, even though they're wearing the banner or the uniform, or any other particular employee, like, say, a custodian or someone else in the school district. So all of these questions, I think, are really fascinating in the context of the First Amendment. And so where do you see this case going in terms of the significance overall to First Amendment jurisprudence? Because I know there were a couple questions from Justice Gorsuch as well about the Lemon test and, some of these, case from like back in the 1970s that's really actually fallen out of favor with the courts to provide this specific analysis for First Amendment jurisprudence. So what would you like to see overall come from the Supreme Court in terms of a metric for analyzing speech, not just obviously a win for your client?
Right. So we would like to see that this being recognized as private speech and that you can't single out private speech for discrimination on the basis of religion. And then also, if they could clarify the Establishment Clause law, which, as you mentioned, is in desperate need of clarification, that would be the cherry on top. Because I believe it was Justice Kavanaugh who said that we haven't used some of these tests in decades. The Supreme Court hasn't used the Lemon test in 2 decades, but still lower courts still believe they have to use it. And that is one of the reasons why what we see a hostility toward religion. A lot of school districts misunderstand their requirements and think that they have to scrub campuses of anything that partakes of the religious, anything that's even remotely religious, and that can lead to them overcorrecting and going too far sometimes to infringe on the private rights of teachers and students.
And that's a really great point. I mean, this type of analysis and the significance of arguments in front of the U.S. Supreme Court is that it can clarify and provide guidance to lower courts and to school districts who maybe want to faithfully apply what they believe is the current law, and they are overcorrecting, and this is causing a lot of ultimately the problems like what Coach Kennedy himself personally recognized. And, I ended up being able to meet Coach Kennedy probably this was about 5 years ago, I think, with your senior counsel, Kelly Shackelford. And at the time I was working for Dr. Dobson, they came into the studio, and, he is just such a wonderful example of someone who's willing to stand up and engage in these types of legal battles that he never thought he would have to, I don't think, just like Jack Phillips of Masterpiece Cake Shop. I mean, some of these people who are unwittingly and definitely unintentionally finding themselves at the spearhead of some of these cases. And so just from what you've been able to observe from Coach Kennedy as well, how do you think that this has played out for him personally, and what was his attitude facing finally getting his hearing today in front of the Supreme Court?
Well, as you know from just meeting him for a few minutes, he's a fighter. And so he's willing to stand up for what is right. And it's been a long journey. It's been, 7 years now since this whole ordeal started. And so we're hoping that we can obtain a victory for the coach who's put everything on the line for freedom, for not only his freedom, for the freedom for religious liberty across the nation.
Yeah, absolutely. And from, kind of a greater philosophical context, I mean, there are so many conservatives now that say, well, our Constitution is dead. We've completely, the Biden administration has completely warped everything. And obviously, you're a nonprofit, you don't get political. So certainly not asking you those types of questions, but just from an overall conservative and constitutional vantage point, is this a win in terms of where we see the Supreme Court headed in terms of jurisprudence just by taking up the case finally, and for conservatives to maybe have some kind of confidence that our Constitution and the protections that it affords people like Coach Kennedy are still very much alive and well?
There's hope. We're seeing the fact that they took this case, that a lot of the trends in their recent cases is moving in the right direction. Maybe it's not moving as quickly as some on the right would hope, but it is moving in the right direction toward protecting religious freedom for all, for protecting our overall First Amendment rights of free speech for all, no matter what your background is, no matter what your perspective is. So we're hoping that trend will continue and that this court will really stand up for First Amendment principles overall.
Yeah, absolutely. Well, thank you so much. I really appreciate it so much, Stephanie. And you all do such great work at First Liberty, and I'm so happy to help amplify this and support you. So where can people who are seeing all the great work that you do as a nonprofit, where can they go to find out more about your clients, how they can help support First Liberty?
Well, they can follow us and all of our cases at firstliberty.org.
Great. All right. Well, thank you so much, and wish you success. And I'll look forward to hopefully speaking with you again when we can celebrate a victory in a few months.
Wonderful. Thank you again.
Thanks. All right, well, 2022 is going to be a critical year for America. AMAC, the Association of Mature American Citizens, along with their nearly 2 million members. The fight to stop out-of-control spending in the president's Build Back Better scheme is far from over, and Congress is plotting more legislation that could hurt our seniors. The midterm elections will be a battle for freedom versus socialism. Unlike liberal groups, AMAC is America's conservative, action-oriented 50-plus organization fighting hard every day here in Washington and across the nation for our seniors. So I'm urging you to choose AMAC now. You will receive all of the great membership benefits, including AMAC discounts on hotels, travels, and restaurants, and your membership will support your conservative values. So go to amac.us/Ellis. That's amac.us/ELLIS to become an AMAC member now.